Welcome back. Let's take you straight to the Supreme Court of Appeal in Bloemfontein. That's where Dr. Nandipha Magudumana is making yet another appeal to overturn her arrest and extradition from Tanzania. Let's listen in.
In paragraph 83 of our heads of argument, we suggest that there are two types of orders that should be granted. One is a simple prayer that says the appeal is upheld with costs, including the costs of two counsel. And the other is a prayer with 5 subheadings. And for today's purposes, we are only going to ask the court to grant 2.1, 2.4, and 2.5. And we're going to submit at the end, when it comes to remedy, that 2.2 and 2.3 are not necessary and we do not move for those orders. The basis of our case is that it is accepted, we submit, that the notion of disguised extradition is unlawful in international law. It violates the Constitution, and we submit that if ever there was a case on the facts for a disguised extradition, this is it. The facts present, we submit, clearly demonstrate that there is or was a disguised extradition, and to demonstrate that, we are going to ask that our argument be divided into 6 chapters. I'll take the court through the chapters after I beg leave to hand up a small bundle of the authorities that I'm going to in particular refer to during my argument. It is something that we debated in chambers, and perhaps then you will see the 6 chapters divided into the contents page of these further submissions. We've prepared it just to make things easier. There's one case in this little bundle which is not referred to in our heads of argument, and I'll explain why. It's a case dealing with remedy, which only arose after our learned friends' heads of argument were filed. And I'll explain how it came about that that case is of relevance today. But the court will see this, in the bundle there are 5 headings. One sees the rule of law and public opinion. Those are items 1 to 3. Then the importance of extradition and the distinction between deportation and extradition, and there are 3 items. Then a pleadings chapter, and the last is a remedy chapter. Those are the 5 headings. There's one other heading, perhaps I should just highlight, which we haven't included in this bundle as a separate chapter, but that's on the question of waiver, or the consent to extradition. But for purposes of that chapter, included in the bundle is the Muhammad case, which is item 4, which is pages 14 to 20. And in particular on page 18, there is a paragraph in the judgment of the Constitutional Court, it's paragraph 64, which we submit should dominate this court's thinking when it comes to the question of was there consent by the appellant to be, and I use the word very carefully and very specifically, handed over to the South African government. Handed over. On the same day, a notice of prohibition was signed, and she says, it's not contested, that she saw it for the first time, that she saw the prohibited immigrant's notice for the first time when it was filed as part of the papers in this case. There's no suggestion that it was given to her, that she saw it, that she knew her rights. There's none of those issues. The simple issue that they raise is on the papers, which I'll come to when I deal with that chapter. So let me turn to the first chapter, which is the rule of law and public opinion. We submit that in this case, our experience tells us that there's an elephant in this room. And the elephant is that the appellant did a bad thing. She committed a serious crime and she must pay for it. That's public opinion. It's hard to find anybody not that I live in the Twitter sphere or the X sphere, where one looks at the News 24 comments on, there's an article in TV or in the news, and then one sees people comment. And almost unanimously, the people say, she must do the time that she deserves. And that's what we would call the public opinion balancing. On the other hand, is what is the law? What is the rule of law? What does it mean? And should the rule of law bend to what the public think should happen? And we have in our bundle 3 little extracts. And the first is the first case of the Constitutional Court, S versus Makwanyani, where there's a heading, the public opinion. It's on page 2, and perhaps I should just take the court through these various headings. And the Jaskelson P deals with public opinion. And he says the Attorney General argued that it was cruel, inhuman, or degrading depends to a large extent upon contemporary attitudes within society, and that South African society does not, etc. And we emphasize what is said in paragraph 88 and 89. Public opinion may have some relevance, but in itself is no substitute for the duty vested in the courts to interpret the Constitution and to uphold its provisions without fear or favour. If public opinion were to be decisive, there'd be no need for constitutional adjudication. Then I go on a little bit lower at letter E. The very reason for establishing the new legal order and for vesting the power of judicial review of all legislation in the courts was to protect the rights of minorities and others who cannot protect theirs. And then the important 2 sentences. Those who are entitled to claim this protection include the social outcasts and marginalized people of our society. And then the sentence which would always dominate thinking in a case dealing with crime. It is only if there is a willingness to protect the worst and the weakest amongst us that all of us can be secure that our own rights will be protected. Let me emphasize, there must be a willingness by the courts to protect the worst, the bad criminals of society. There needs to be protection, and the weakest amongst us, that all of us can be secure. And then on to the next page, in paragraph 89, there's further dealing with this question of public opinion. I do want to jump forward to the case of West Virginia State Board versus the quote from that case versus Barnett, where Justice Jackson said the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, etc., etc. Our rights may not be submitted to vote, they depend on the outcome of no elections. And we know we're living in a world where elections play an increasingly dominant role in the public space. And especially in this time, with elections playing the role that they do, throughout the world, in every country, it's so important that courts ignore that which public opinion should dominate. And we move on to the next case that we, in this little bundle. It's a case called Tsebe, which the court will have regard to not only for the proposition of this public opinion elephant in the room argument, but also when it comes to remedy. And there, the respondents in the Constitutional Court had succeeded in the High Court, but before the full bench, and the Minister of Home Affairs, together with, I think, Justice, argued that they should be deported, or in that case, be allowed to be deported or extradited to Botswana. And there was a problem because Botswana would not give an undertaking of no death penalty. And I remember I was in the case for the respondents, and one of the questions that was posed was, well, you have people who've committed a brutal murder. Whether they're South Africans or not is not an issue. What happens if we say they can't be deported for whatever reasons? And my answer was, which is now contained in the judgment, that's the price we pay as a society for having the rights that we have. And if individuals who've committed brutal murders or committed terrible crimes have to go free, that's the price we pay by having a constitution. And those are the words that then acting Justice Zondo, who became the Chief Justice, now retired, said, next to between the letters E and F, he said, One of those things is that no matter who the person is and no matter what the crime is that he's alleged to have committed, we shall not be in any way party to the punishment, and we will not hand such person over. The path that we as a country have chosen for ourselves is not an easy one. Some of the consequences that may result from our choice are part of the price that we must be prepared to pay as a nation for the advancement of human rights and the creation of the kind of society and world that we may ultimately achieve if we are to abide by the constitutional values that now underpin our new society since the end of apartheid. And we would say this is part of this introductory chapter. Public opinion, there's a law here. And we say, we move on. Just in passing, on the next page, page 8, next to that's G, we see that first the alleged killing was brutal. In Botswana, they talk about this. So these are really not good people. And then the next case that we've included is Alvarez Machine, which is referred to in our heads of argument, and it's referred to in the Mohammed case. And we would ask, and this is important from a different perspective. This court knows very well that previously it had ruled in the Ibrahim case in a particular way. And what happened was there was an abduction by the apartheid government of somebody in Swaziland, and this court, overturning the High Court, found that that abduction from Swaziland divested the courts in South Africa of jurisdiction. And you see reference to that case, the Ibrahim case, on page 12. It's reported in April, June, South African law reports. This is on page 12 in the US Supreme Court judgment. And what happened in the US Supreme Court, there were nine justices in the US Supreme Court, and Dr. Alvarez Machine was in Mexico. He was alleged to be part of a drug conspiracy, involved in horrible murders and the like. And the US Drug Enforcement Agency, a US government agency, abducted him into the US, and he took the point, I was abducted, disguised extradition, or whatever it was. Therefore, the criminal trial courts in the US don't enjoy jurisdiction. The case went all the way up to the Supreme Court, and there was a 6-3 split. The 6 said, the courts in the US do have jurisdiction. The 3, the dissenting minority, found that the courts in the US would not exercise jurisdiction. And the importance of the dissent, which we would emphasize, are the words that Justice Stevens said dissenting. He says, and starts on page, the dissent starts on page 11, and he says the court's admittedly shocking disdain for customary and conventional international law principles, and he says with reference, is thus entirely supported by case law and commentary. It's not. Then he goes on, syllabus 4. As the court observes at the outset of its opinion, that means the majority. When he talks about the court, he's meaning the 6. There's reason to believe that respondent participated, this is Dr. Alvarez Machine, in an especially brutal murder of an American law enforcement agent. That fact, if true, may explain the executive's intense interest in punishing respondent in our courts. We could almost have that here. That here, the appellant is alleged to have done horrible things. And then he says, if true, it explains why the executive has an intense interest in punishing, in that case, Dr. Machine.
All right, so those are live visuals from inside the Supreme Court of Appeal unfolding in Bloemfontein. Speaking there is Advocate Anton Katz, SC, representing Dr. Nandipha Magudumana. She, of course, is trying to nullify her arrest in Tanzania once again. Very interesting arguments being made as he lays the foundation for why they reckon that her extradition was unlawful. My goodness, what a fiery exchange between Anton Katz, SC, representing Dr. Nandipha Magudumana, and some of the justices there in the Supreme Court of Appeal in Bloemfontein. At the heart of the back and forth, which has really been sustained for a couple of minutes now, is whether or not the police on the South African side actually followed the letter of the law in how they effectively got Nandipha Magudumana back. And what I've been able to glean from what Anton Katz is saying is that at the very least she was meant to be given a prohibited immigrant notice, which would, according to him, give her 3 days to leave the country, no matter where she goes. Alternatively, the South African government was meant to put together an extradition application, and we know typically how long those could take, and who knows what could happen in the interim as that application is being finalized. But at the heart of the back and forth, it really can get technical, as I think even some of the justices and the advocate there tie themselves in a couple of knots. At the heart of it is whether or not the idea to bring Nandipha Magudumana back into the country immediately, whether or not that in fact was lawful. And he started off by just laying the foundation that this idea that Nandipha Magudumana needs to be held accountable for doing something really bad cannot stand in a court of law, because that's just the sentiment in the public domain. And of course, we know at the heart of it, the widespread perception is that Nandipha Magudumana helped Thabo Bester escape from prison, and the many other people who had to pay a very high cost in order to pull that off. So we'll continue listening in to that application for you as it continues there in the Supreme Court of Appeal. But